and welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host Ostika Das and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In today's episode, we are going to talk about the Supreme Court's verdict in the Bilkis Bano case, the Constitution Bench hearings of pleas concerning Aligarh Muslim University's minority status, the top court's refusal to stay the new law dropping Chief Justice of India from the panel selecting election commissioners, and much more. So let's dive into the headlines. In a landmark judgment, the Supreme Court this week overturned the premature release of 11 convicts involved in the heinous gang rape of Bilkis Bano and several murders during the 2002 Gujarat riots. The court declared that the state of Gujarat lacked the authority to grant remission as a trial had taken place in Maharashtra. The release orders were deemed invalid and the convicts were directed to surrender within 2 weeks. The court addressed 5 key issues in its ruling. It upheld the maintainability of Bano's petition under Article 32, but refrained from ruling on the maintainability of the public interest litigation since the victim herself was before the top court. Most notable was its verdict on the competency of the Gujarat government to decide the remission applications of the convict. It found the remission orders in violation of the rule of law as Gujarat had overstepped its jurisdiction. Interestingly, it was the top court's judgment that triggered the series of events resulting in the release of the 11 convicts. By this ruling, the Supreme Court in May 2022 had allowed the writ petition of one of the convicts, Radhesham Shah, holding that the Gujarat government was the appropriate government to decide the application within the meaning of Section 432 of the Code of Criminal Procedure. Justice Nagaratna, who authored the judgment in the Bilkis Bano case on behalf of herself and her brother Judge Justice Ujjal Bhuiya, however, observed that the May 2022 verdict had been obtained by making misleading statements and suppressing material facts, including that the Gujarat High Court had already asked the convict to approach the state of Maharashtra in a writ petition. The court also criticized the state of Gujarat for not seeking a review of its May 2022 judgment, despite submitting in their pleadings that the state of Maharashtra was the appropriate government. The state government had acted in tandem and was complicit with the convict who approached the Supreme Court, the Justice Nagaratna-led bench found. Besides this, it also found that the earlier judgment was per incuriam, which basically means that it was held to have been handed out in ignorance of binding precedents and relevant statutory provisions. Finally, the court deliberated the delicate issue of the consequences after setting aside the remission orders, weighing the rule of law against the convict's personal liberty. Underscoring the paramountcy of the rule of law, the bench ultimately ordered the convicts back to prison. To learn more about this judgment and the various factual and legal aspects covered in it, please visit our website www.livelaw.in. On 9 January, a 7-judge constitution bench led by Chief Justice D.Y. Chandrachud initiated hearings on the pleas concerning Aligarh Muslim University's minority status. The petitions in this case challenged a 2006 Allahabad High Court decision asserting that although AMU was established by a minority community, it was never administered as such, disputing its minority institution status. On day 1, senior advocate Dr. Rajiv Dhawan presented arguments addressing the constitutional aspect of whether a university established by a statute, like the AMU Act of 1920, can be deemed a minority institution under Article 30 of the Constitution. The key issues raised include reconsidering the 1967 Aziz Basha case in which AMU's minority status was considered by the top court for the first time, assessing the impact of the National Commission of Minority Education Institutions Act, and defining the essence of minority under Article 30. Continuing the hearing on the university's minority status, the Supreme Court noted on the second day that the requirement to administer under Article 30 of the Constitution may not be absolute for an educational institution to qualify as having a minority character. The discussion focused on the nuanced difference between establishment on one hand and administration on the other, with the Chief Justice remarking that a minority community would have a chance to not only establish an institution but also to choose to have the institution administered by someone else, and that does not necessarily hinder the institution's minority status. Senior advocate Kapil Sibal, representing AMU Old Boys Association, underscored the historical context of AMU's establishment, addressing the faults in the Aziz Basha case and arguing for a clear distinction between establishment and recognition. Sibal contended that understanding the term establish requires delving into the purpose of the establishment. In this connection, he emphasized the university's purpose of empowering minority communities. On day 3, the Constitution Bench questioned the significance of the minority tag for the institution, considering its long-standing status as an institute of national importance for over a century. Justice Dipankar Datta asked how it mattered for the people whether AMU held the minority institution status, emphasizing that it has been a nationally important institution without the tag. Advocate Shadan Farasat, representing one of the petitioners supporting AMU's minority claim, argued that the university enjoyed minority status until the 1967 Aziz Basha judgment. He noted that the 1981 amendment granted minority status, and despite a 2006 Allahabad High Court decision, the status quo orders maintained AMU's minority institution status. The discussion extended to whether any other minority institution received 100% central funding, with Farasat suggesting that Jamia Millia Islamia might be one such institution. The petitioners highlighted the role of AMU in developing an educated Muslim class and fostering women's education. In defense of the minority tag, senior advocate Salman Khurshid also cited its importance to preserve the cultural ethos of the institution. Additionally, the court on the third day explored the consequences of if the Aziz Basha decision were deemed erroneous and delved into the distinct meanings of established in constitutional and statutory senses. The hearing will continue on 23rd January, so stay tuned. The Supreme Court took up a plea by Congress leader Jaya Thakur challenging the constitutionality of Section 7 and 8 of the Chief Election Commissioner and other election commissioners' appointment conditions of service and term of office Act of 2023. For more context, the Election Commissioners Act, which recently got presidential assent after being passed by the Parliament during the winter session, aims to streamline the appointment process for top election officials in India, replacing the Election Commission Conditions of Service of Election Commissioners and Transaction of Business Act of 1991. Notably, the new act excludes the Chief Justice of India from the selection committee for the appointment of election commissioners, marking a departure from the verdict of a constitution bench of the Supreme Court that had in March last year ruled that election commissioners shall be selected by a committee comprising the Prime Minister, the Leader of Opposition and the Chief Justice till the Parliament frames a new law prescribing the selection process. The bench, led by Justice K.M. Joseph, who is since retired, passed the direction to ensure the independence of the election commissioners and the Election Commission of India. Jaya Thakur has contended that the removal of the Chief Justice from this committee violates constitutional principles, asserting that it is against Articles 14, 21, 50 and 324 of the Constitution and compromises free and fair elections. The petition draws on the Supreme Court ruling from March, emphasizing the need for an unbiased selection panel and the inclusion of the Chief Justice in the appointment process. While agreeing to hear the Congress leader's petition, the Supreme Court, however, categorically refused to grant her request for an immediate stay on the new legislation. This matter has now been posted for hearing in April. In another significant development, the Supreme Court has agreed to form a bench to address concerns raised in a plea seeking the abolition of the collegium system for appointing judges in the Supreme Court and High Courts. This writ petition, which stresses the need to dismantle the existing system, was filed by Advocate Matthews Nedumpara back in 2022. Now, he's underscored the urgency of the plea this week by pointing to the recent remarks of retired Justice Sanjay Kishan Kaul, who in a December 2023 interview flagged faults in the current collegium system. Justice Kaul, a former member of the collegium, highlighted internal frictions within the system, tracing them back to the Supreme Court's 2015 decision to invalidate the National Judicial Appointments Commission Act. The judge noted that the striking down of this had caused discord and led to angst amongst political circles who had unanimously passed the law. The pendency of the names recommended by the collegium to the government are a reflection of this present friction, the former judge said in his interview. In response to these concerns, Chief Justice of India D.Y. Chandrachud acknowledged the need for a dedicated bench to address these issues raised in Nedumpara's petition. This week, an application was filed on behalf of the Uddhav Thackeray-led faction of Shiv Sena, questioning the impartiality of Maharashtra Speaker Rahul Narvekar in deciding disqualification petitions against Eknath Shinde faction members. The application alleged that the Speaker met Chief Minister Eknath Shinde just 3 days before the disqualification verdict, raising concerns about impartiality. Filed by Sunil Prabhu, the application argued that such actions violate the principle that justice should not only be done, but also seen to be done. This was part of a writ petition urging the Speaker to promptly decide the disqualification petitions. Expressing dissatisfaction over the Speaker's delay in adjudication, the top court had initially directed him to decide the applications by December 31st, 2023, but later extended the deadline to January 10th. In related news, on January 10th, Speaker Rahul Narvekar declared the Eknath Shinde-led faction as a real Shiv Sena following the party split on June 22nd, 2022. He refused to disqualify members from both factions led by Shinde and Uddhav Thackeray. The factions had filed 34 petitions seeking the disqualification of 54 MLAs. The UBT faction had submitted that the decision of the Paksha Pramukh is synonymous with the will of the party, which is why if there is a rift in the leadership structure, the Paksha Pramukh's decision represents the will of the party. Disagreeing, Speaker Narvekar said that Shinde's faction had an overwhelming majority of 37 of 55 MLAs when rival factions emerged and that he was validly appointed as the leader of the party. He said that the will of the party Paksha Pramukh, at the time Uddhav Thackeray, cannot be said to be the will of the political party. To reach this conclusion, the Speaker relied on the 1999 constitution of the party, which had diluted the power from the hands of the party chief. He revealed that the 2018 constitution, which concentrated power back in the hands of the party chief, is not on the Election Commission's record and thus cannot be taken into account by him. While rejecting disqualification pleas challenging Shinde faction membership of the State Assembly, the Speaker also cited Sunil Prabhu's loss of authority as the authorized whip. He also stated that dissent within the party is protected by freedom of speech, cautioning against a misuse of the 10th schedule for intra-party discipline. The Supreme Court has declined to intervene in the Allahabad High Court's decision affirming the acquittal of Union Minister of State for Home Affairs Ajay Mishra Teni in the 2000 murder case of student leader Prabhat Gupta. The lower court had acquitted Teni in 2004, a decision contested by the complainant Prabhat Gupta's father, leading to a revision plea in the High Court. After the High Court rejected the request for revision, the matter reached the Supreme Court. The case involved allegations that Teni, in a dispute over panchayat elections, orchestrated the daylight murder of Prabhat Gupta along with a co-accused. Teni argued that the trial court had rightfully acquitted him as it deemed the eyewitness testimony unreliable. The Supreme Court, presided over by Justices Bela M. Trivedi and Pankaj Mithal, expressed unwillingness to interfere with the consistent findings of both the High Court and the trial court. The High Court had held that the acquittal order by the trial court was plausible and sustainable after concluding that the evidence had been correctly appreciated and that there was no perversity in the decision. It had also noted that the law assumes a double presumption in favor of the accused after a thorough trial court adjudication. The Supreme Court granted protection from arrest to BJP legislator and Minister of State for Home Affairs Nishit Pramanik in an attempted murder case in West Bengal. This order will remain in effect until the Calcutta High Court hears his petition. Pramanik approached the Supreme Court after the High Court adjourned his anticipatory bail plea without granting him relief. The top court bench, comprising Justices Bela M. Trivedi and Pankaj Mithal, heard his plea one day after issuing notice, acceding to his request for an urgent hearing on grounds of the allegedly volatile political situation in West Bengal and Pramanik's role as a minister. During the hearing, senior advocate P.S. Patpalia sought interim protection until the next circuit bench session on January 22nd. The state government, however, assured that no arrest would be made until then, but Patpalia insisted on a formal recording of a direction against any coercive steps in the order. While adding such a direction in its order that no coercive action will be taken against the minister, the bench also clarified that it had not expressed an opinion on the case's merits. The Supreme Court has directed the impleadment of the Delhi High Court, seeking its response in a judicial officer's appeal to expunge remarks made against him by a High Court judge. The three-judge bench, comprising Justices Aniruddha Bose, P.S. Narasimha and Arvind Kumar, instructed the amendment of the cause title and notification to the Registrar General of the Delhi High Court. This case originates from the additional sessions judge's comments against two police officials involved in a theft case investigation. The judge's remarks suggesting something, and I quote, fishy, and ordering an inquiry into the police officials' conduct were contested by the police in the High Court. The Delhi High Court in response set aside the remarks, deeming them excessively exaggerated and beyond the expected judicial conduct. The court criticized the judge's overreach into administrative functions and called the directions disproportionate. In response, the aggrieved judge moved the Supreme Court. The Delhi High Court had earlier emphasized the need for judicial strictures to be cautiously passed, recognizing their potential impact on the professional careers of officers. We have an alarming development from our High Court. In response to a habeas corpus petition filed by a woman in a queer relationship, Justice Pankaj Jain of the Punjab and Haryana High Court expressed skepticism about the distinction between morality and constitutionality. Questioning the petitioner's representation capacity in a case involving a queer couple, Justice Jain remarked, and I quote, "Take this immoral thing back to where it came from." He reiterated his rejection of the theory that constitutionality and morality are separate, swiftly moving on to the next matter. This case will now be listed before Justice Sandeep Modgil. The petitioner has alleged the unlawful detention of her partner by the partner's family, opposed to their relationship, and has claimed mistreatment by the police when seeking protection. Justice Modgil's bench had earlier flagged conflicting Aadhaar card reflecting different birth dates for the alleged detainee, raising issues of majority status. In an evening order, Justice Jain noted the petitioner's inability to establish herself as the next best friend of the alleged detainee, directing the matter to be listed before a regular bench. If you remember, the Supreme Court, while refraining from granting legal recognition to queer marriages, had urged states to address discrimination against queer couples and ensure protection for their right to cohabitation. The Punjab and Haryana High Court had also previously granted protection to a lesbian couple, affirming that Article 21 applies to same-gender couples as well. This case is scheduled for January 15th for further hearing. The Gujarat High Court has rejected an appeal by former Indian Police Service officer Sanjeev Bhatt, challenging his conviction and life imprisonment in connection with a custodial torture and death case dating back to 1990. The incident involved the death of Prabhudas Madhavji Vaishnani due to alleged custodial torture during Bhatt's tenure as Assistant Superintendent of Police in Jamnagar. Bhatt, along with other officers, had detained 133 individuals for rioting. Vaishnani, who spent 9 days in custody, died 10 days after release on bail, his death being attributed to renal failure. In 2019, a Sessions Court sentenced Bhatt and a police constable to life imprisonment for murder, voluntarily causing hurt, and criminal intimidation. Other officers were also convicted of custodial torture. Bhatt and others have appealed their conviction, but the High Court upheld the lower court's decision. The bench stated that the reasoning of the Jamnagar court was correct, finding no grounds for interference. It emphasized Bhatt's significant role in the incident, including ordering the beating of witnesses, making them do sit-ups and other forms of abuse. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic Six. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host, Ostika Das, and I will see you again next time.